It is our duty to shine the light of truth, to bring justice to the restless souls whose lives were lost to their hands. Rise up against the evildoers of this world so that their souls may have peace. We will not surrender. We will fight. We will stand for what is right because we are the Justice Warriors.
Hello, Justice Warriors. Come on in. We are about to have a discussion about the Swift trial. David Swift was on trial last week and the week before, and we are here to discuss that and dissect it. Tracey and I here. So we're going to start today with opening statements. Danny Goodman, General Goodman, came out with a bang. His opening statements were had everything that he had said in them been true, or if he had been able to prove the things that he claimed in the opening statements, we would be in a much different place right now. But Mr. Goodman, General Goodman, did have a theory, and his theory, the theory that they had put together with the circumstantial evidence that they had, was that David Swift had premeditated, had planned to kill Miss Karen Swift, and that he stomped her head into the ground in the garage, loaded her body into the back of her own vehicle, took her body to the Bledsoe Cemetery, dumped it there, dragged her body down, I guess about 20 feet is what they said it would have been from, I guess, where they believe he had parked the car. Drug her feet down 20 feet, left her body there in some kudzu, took the car back. I'm a little fuzzy on whether they think he went back to the house first or if he just dumped the car on his way and then walked back to the house.
I think they're fuzzy on that too.
Right. It just, none of it seemed to line up, but I digress because we're getting ahead of ourselves right now. Just the opening statements. In the opening statements, the claim was that he had taken her body to the Bledsoe Cemetery, dumped it there, then proceeded to abandon her vehicle on the side of the road with a nail in the tire. They claim that he must have let air out of the valve because it wasn't all the way flat. And then he walks back to the house. The defense, of course, came back, and their response to the state's opening statements was basically great story, but asking the jurors, please look for the proof. There is no proof of this. And General Goodman did concede in his opening statements that this was not a case where you were going to see evidence. You're not going to see DNA evidence. You're not going to see fingerprints. But clearly they felt that from these different pieces of circumstantial evidence that they did have that consisted of things like cell phone data, computer data, computer or a forensic expert on the tire, things like that, they felt that the jury should be able to conclude from those pieces of information that David Swift did in fact kill his wife. Of course, the defense attorney, Daniel Taylor, his response to this was, where's the proof? If there's no proof, you can't convict this man. So that's the best summary I can give. How do you feel about, what do you think right now about that? Do you have anything to add, Tracey?
About just the summary,
Just the opening, just the opening statements. What do you have to add?
Well,
opening statements.
From what I knew, because I knew the case, I just went from, man, he's going from, I didn't find it as impressive as you did. I went from I thought he went from A to D to 17 to B, whereas it
The
should have
zebra.
gone 1, 2, 3, 4, 5. And it just was very, it
Well,
was not woven together well, and it was not woven together well with anything other than a theory.
I agree. But I was
They don't know how she died. They don't even know how she died.
well, that became more apparent later in the trial, but in the beginning they came out swinging, like they knew. And I was trying to take what I know out of it and to listen to it with juror ears, you know. And from that, if I didn't know any of the things I knew, and if I was, you know, just coming into this case, didn't know anything, it was a great story. It was compelling. And that's really all it was with both the opening and the closing statements. The prosecution told a great story. The problem is the meat and potatoes of the case, you know, the opening statement, the closing statement, slam dunk. The meat and potatoes of the case, the proof of the case fell short, fell very, very short. So I want to discuss some of the witness statements themselves. All right, we'll start with why don't we start with Bill and Kathy? That's a fun place to start. um, so Bill was first, and Bill, yeah, Bill claimed that well, specifically just talking about an incident that had occurred there at their house involving Karen. There was a night that, and from what I understand, and I'm having to take some other pieces to put this together for you, but basically, Bill and Kathy had been at Dina Katormas's birthday party that night. And we know this because of Kathy Bona's original statement to law enforcement. Okay. So I'm kind of
It's corroborated.
right. Well, right. I mean, we wouldn't have known that if Daniel Taylor hadn't broken out the transcripts and basically like pulling teeth, pulled it out of her. But we know that this particular night that is in question, that they're talking about on at the trial, was Dina Katormas's I believe 40th birthday party, I think they said. I could be wrong. But anyways, about the age. Yeah, whatever. It doesn't matter. It was her birthday party. And in Kathy Bona's original statements to law enforcement, she tells them that they had just gotten back from Dina's birthday party. She did not specify who they were. She didn't say me and Bill and Karen. She just said we. But we know that Karen was at their house with them afterwards. So that particular night, this is one of the incidents that was discussed, that Karen was upstairs in bed with Kathy. David shows up. He's upset. He goes upstairs and he finds Karen in bed with Kathy. He gets upset. Apparently, according to Kathy's testimony, she was fully clothed wearing pajamas. Now, we don't know if these were sexy little lingerie pajamas or if these were, you know, it's the middle of winter zip up footy pajamas. We have no idea.
Or the king's pajamas.
Right. We have no idea.
You know what I mean?
But
With
these are,
invisible pajamas.
oh, invisible pajamas, right? I had no idea what you're talking about. That's a good one. Good one, Tracy. But and supposedly Karen was had just gotten out of the hot tub and had a towel wrapped around her and was in the bed with Kathy, and Kathy was supposedly under the covers. It seemed like, she was going above and beyond to try to convince the court that she's fully clothed under the covers, Karen's on top of the covers, and it's not really so much of an issue.
And nude too. Karen was nude.
Yeah, she was nude, but she had a towel wrapped around her supposedly. But that incident, the state was one of many incidents that the state tried to use to really paint David as being controlling and jealous, and because he had shown up uninvited to their house, caught Karen in the bed, was upset with her, asking her, "What are you doing?" And then storms out of the house. But I think it's very important to note with that he didn't become physical with her. He confronted her and then he left. And that was the extent of that. The next incident that Bill and Kathy Bona really talk about is an incident that occurred just after Kathy's 40th birthday party at the Farms Golf Club. And that incident, there was a little bit of conflict between the statements of what really happened that night. Because Kathy talks about, she and I feel like she was trying to almost cover for her husband. But she claims that she was in the kitchen where she could actually see, and they had to kind of get it out of her that she wasn't, in the room, because she was trying to testify as if she was actually in the room, and she was not. So she couldn't really say what did or did happen that night. But as the story goes, Karen had been in the hot tub naked, and she got up out of the hot tub and walked into the house, supposedly because she's feeling woozy. She had had a little
Because
bit
she's been drinking.
and
Right.
she was hot or whatever. So she goes into the living room in the Bona's home. She lays down naked on top of a pillow or a cushion of some sort that's on their floor. And this is where it gets weird, because there was conflict over whether Bill Bona put a towel over Karen or whether it was Robin Alford. And Robin Alford, there was some drama between Robin and Kathy and Bill, because Robin had actually told David about what had happened. From what I understand, she had called David into that because David was actually there. He was outside talking to some people or whatever.
He was invited to that party.
That's the only party apparently that he was invited to. And so David was outside, Karen had walked inside, Bill followed her. Kathy tried to testify for Bill that he put a towel over her, but it was pretty much decided in court that her testimony really wasn't valid because she was not in the room. So the controversy is whether Robin Alford was telling the truth or whether Bill Bona was telling the truth, because Robin claimed that when she came into the room that Bill Bona was standing over Karen, gawking at her, looking at her weird, whatever, and that she had come in with a towel and she was the one that covered Karen. What was interesting about Robin Alford's testimony was that the state tried to trip her up And in doing that, they had put a piece of paper in front of her and they were like, this is what your original statement says. But she had watched her video interview before the trial so that she could refresh her memory. So she had already seen that and she knew that it didn't say that. So she stood her ground. And they were putting this piece of paper in front of her like it was a transcript of her interview, when in fact, it was a summary that somebody had typed up where it seems that they had kind of made some small adjustment. And Robin stood her ground.
And big lesson to learn about that for me and everyone else. Make sure if you ever have the interview taped, videotaped, and then do exactly as she did. I did not realize they could legally shove a summary, which is a summary is more of an opinion. What word am I looking for? Someone
Well, a summary
else's
is a
decision.
summary. Yeah, a summary is a summary. And basically, this person, and they were so, throughout the trial, they were so adamant about every document being certified, being authenticated, so on and so forth. And for that summary to be used, I'm like, okay, well, who typed up that summary? That summary was not an authenticated document. They tried to, from what I feel personally, that they were trying to pass that off as a transcript, and they were hoping
Yeah,
that nobody would catch that.
yeah, no harm, no foul.
Well, it was a lot of harm and a lot of foul. And thank God Robin Alford stood her ground and was like, nay, nay, that is not what I said. And
She's my hero. She's one of my heroes.
she was fantastic. She was really, what I loved most about Robin's testimony was that Robin, she was unbiased. She was not trying to speak ill of Karen. She reiterated multiple times that Karen was a wonderful mother. Nobody has ever doubted that. We've never doubted that. She was a good mom. She loved her kids. Whatever was going on in her life at that time, um, it, in my mind at least, I don't think that made her a bad mom. But Robin made that very clear. She was unbiased. She was not trying to speak ill of Karen. She was just trying to speak the truth, speak her truth. That was the truth. That was what she witnessed, and that was what she said in her original statement. And they tried to trip her up, and it was, well, it
It
backfired.
was, I know the word I was looking for. A summary is biased because it's done by a person who decides what to put into the summary.
Well, it's their perception. It's
Right.
a summarized version. It's their perception of what that person said.
Correct. Of what they might need.
And I don't think for 1 minute that it was, an accident or it was innocently done. For them to, it was manipulative. I think it was very manipulative. But back to, so Bill Bona says he put the towel over her. Robin says she put the towel over her. But what is the point of all this, you may ask? The point is that there were other people that should have been investigated, and Bill Bona was one of them. And even the jury, who knew nothing about Bill and Kathy or some of these other players, even the jury picked up on that. We'll talk more about that later. I'll get through the trial part of it first before we start talking about some of the jurors' opinions and the things that we've been told up to this point. So the state presented, some of the evidence that the state presented was they had presented cell phone data and also some computer data. And from their cell phone data, they were able to come up with a timeline that I mean, there were some parts of it that,
Were questionable because the other expert kind of gave a different one, but
right, but it was close enough that I think we can all pretty much agree on the skeleton of it, at least. Maybe not, there's maybe parts of it that are not quite, that might be a little bit questionable, but for the most part, I think we can pretty much agree on the timeline. So what that timeline tells us is that at 2:08 a.m., Karen arrived at home with her daughter, Ashley. And then we know from Ashley's testimony that her mother laid down with her in her bed. And we also know from Ashley's testimony that her mother got up and carried her into her sister's bed as well. Or I'm sorry, around 3 o'clock is what she had told us. I don't think it was testified. She never said on the stand that it was about 3, but in her testimony to me, she said that she looked up at the clock and she remembers seeing 3 o'clock. Maybe she wasn't 100% sure on that, so she didn't swear to it on the stand, but that is what she told me. So we know that from the state's evidence, from the gosh darn it, I'm sorry, this thing keeps closing out on me and it's starting to, I've got the timeline here in front of me and it keeps closing out and I'm starting to get irritated with it. So about 3 o'clock, she puts Ashley into bed with her sister Keely. Now, the state challenged this because, and now I'm jumping ahead to the defense's witness now because Ashley was a witness for the defense, but the state really challenged how Ashley knew that was her mother. And Ashley was adamant, I know the way my mother feels. And I think most of us can
they're
agree.
called boobs, Ed. They're called boobs.
Oh God, that hurt. You made me, that hurt. That hurt my ribs. I laughed so hard.
Well, you know, when you snuggle your child, that's where they fit.
Right. A mother is just softer, you know? And I know anytime I was moved by like my dad, of course, my dad wasn't really around much, but when I was around my dad, I would wake up, but mom could pick you up and you just like melt into her, you know? It's just the comfort. But anyways, so she puts Ashley into bed with Keely, and then we see internet activity going on. Now, I thought from what I understood, it ended around 3:41, but this timeline I'm seeing here is differs a little bit. But what we do know is that this internet activity that was going on at that time was actually Karen's cell phone connected to a computer, uploading some pictures. And they tried to say that that was David. And the reasoning for believing that it was David was because it was logged into David's user account on the computer. Of course, the defense, their expert would argue, and the defense would argue that, and I agree that when there's like a computer in the house, there's usually one username. Everybody does, when they're on a computer, everybody's under the same username. That's how it is in my house too.
My grandkids know all of my passwords to get on my phone and the computer.
Right, me
I mean,
too.
everybody.
Yeah.
Yeah, everybody does.
So,
And it's not the only computer in the house.
but this is, this is one of many issues with the state's evidence, is that they've got this circumstantial evidence, but it takes speculation to say that was David. Okay, so we've got internet activity. That's a fact. We know that. But was it David or was it Karen? Was Karen actually sitting at the computer uploading pictures from her phone? that would be my opinion of it. But bottom line is that this proved nothing at all, other than that somebody was on the computer. So it's happened again. Give me a second to get back where I was, my Lord. The next part of this is that we know that the cell phone disconnected from Wi-Fi. And the state's witness on this and the defense witness on this had different, they disagreed about what time that the phone actually disconnected from Wi-Fi. The state says 4:38 a.m. and the defense expert says 5:09. For all intents and purposes, we'll just go ahead and go with the 4:38 a.m. We're just going to go ahead and agree with the state on that, which would give us, okay, we've got the first sighting of her vehicle being at 5:55, or I'm sorry, 5:15 a.m. So that would be 4:38, 20, 20, 35, 35, 38, 38 minutes. So I guess what I'm getting at is that the timeline is so narrow, it's such a short amount of time that they are claiming that all of the things that they said that David did were done in this very, very short amount of time. So with the state's timeline, it just doesn't work. It doesn't make sense. We know that the drive from Karen's house to the cemetery would have been about at least 12 minutes round trip if you drove straight there and straight back. We also know from testimony of the physical therapist that David was in fact injured. He had been examined recently, and that physical therapist testified that yes, it would be possible for him to drag a 125-pound body, but that it would have had to have been done in increments. So it's not something he could have done quickly. For them to assert that David did all of this without leaving a shred of evidence, so it would have been extensive cleaning up, in that short amount of time, just didn't make sense. And the jurors did pick up on that as well. A lot of people picked up on that. Tracey, what would you like to add?
About the timeline?
Sure, about anything.
Just-
What do you
Well,
have?
that's where we are, the timeline. I really don't, nobody knows. Nobody knows the exact timeline on either side. So I think they should just bow down and say, right, there's no way this man could have done it. He would have had to have been an Olympian.
Right, right. Even for
Not just not been on crutches, not just not have a hurt knee, but he would have not just a normal regular guy. We're talking somebody that can run track and
right.
And
I mean, at the end of the day, there were just too many problems. And okay, to kind of get into a little bit of what the jurors had said, I've spoken with 3 of the jurors. One reached out to me over Facebook, and the other 2 I spoke to just after the verdict was read and we were all leaving the courtroom or the courthouse, and they pretty much all said the same thing. There were just too many holes in the state's case, in their evidence, in their investigation. And there are just big problems. No DNA, no fingerprints. I mean, just no evidence at all. A timeline that does not add up, and a clearly biased investigation on the part of the state of the Dyer County Sheriff's Office. One of the things that I know stood out to me, I mean, jumped out at me, was when the state's witness, I can't remember her name, but she was a TBI agent. She was the one that tested the fingerprints. They lifted prints off of Karen's vehicle, and those prints were sent to the TBI. But the only prints that they sent for comparison were David Swift's. And, while I don't necessarily feel that John Hogshooter is the one to blame for this, I mean, it's possible. One of the jurors said to me, because, it's always been, I mean, we never really looked that hard at John Hogshooter because of lack of motive. It was like, okay, you know what? I mean, that doesn't make any sense. But this juror says to me, around these parts, somebody kill you just for calling the cops on you. And of course, we know that John Hogshooter had poisoned the Swift's dog and also another neighbor's dog. And he had been charged with that. So could that have been a motive? I don't think it's the strongest motive, but is it possible? It's certainly possible. And for reasons of due diligence, the state should have, at the very least, sent John Hogshooter's prints for comparison, but they didn't. And that spoke volumes. The fact that Bill Bonus prints had not been sent, John Hogshooter's prints had not been sent, and some of these other people that have come up as subjects in this case, all of their prints should have been sent for comparison, just for the simple fact of ruling them out. And I think that what that did, what that spoke to me, what that spoke to the jurors and to pretty much everybody that I've spoken to and that I know of, is that showed just how biased of an investigation it really was.
And the fact that no prints were even found. That his prints were not found. David Swift's prints were not found.
Right. Well, the fact is that when they sent David Swift's prints for comparison, that the TBI was able to exclude him. That was not his prints.
And so why, if they excluded it, why didn't they go, oh, we better go get more prints? We better go get this person. Why didn't they do that?
Yeah, like, what is the problem? Just send some more prints, and maybe they would have gotten a match. Maybe they never would have gotten a match, but they could at least have submitted the prints of the obvious alternate suspects that they never bothered to look at. So, well, another thing I want to mention while we're discussing the car and the prints on the car is the fact that, and this was never brought up at trial, but I'm not sure why it wasn't brought up at trial. And that is the fact that the vehicle was released to Chase Bank for repossession. And when I first started looking at this case and I was shown documentation that vehicle was released to Chase Bank, that was red flags all over the place for me. Because in any murder case, I mean, look at Holly Bobo. Jason Autry's vehicle and I believe Zach Adams's vehicle, they are both still sitting in the impound lot. And it is typical, it is common practice to preserve evidence until after the appeal. I mean, not just until after trial, but you have to keep anything, any evidence, any piece of the crime scene, anything, you have to hold on to that until the appeal process is over, because it could be considered exculpatory evidence because the defense has to have access to it for their own testing. And in this case, the vehicle never would have been available to the defense for them to do their own testing to see if they could find prints and to see if they could figure out who those prints belong. I mean, now they would have access, I would assume, to the prints themselves that the TBI lifted, but they should, or that were lifted and given to the TBI, but they should have still had the ability to test that vehicle, and they didn't because DCSO did get rid of that vehicle. And to hear General Goodman in his opening statements telling the jury that David loaded her body into her own car and then dumped her car, they're essentially admitting that they literally got rid of part of the crime scene.
As they determined it to be.
Right. I mean, they're claiming that he loaded her body into this vehicle, but then they're in the same breath, hey, I mean, of course it didn't come, like I said, it didn't come out in trial, but I mean, I think that, I think it could have been something that Daniel could have used to show, that the investigation was botched. It was biased, it was botched, it was just poorly done.
Can I discuss I don't know where you are on the witness, but it correlates with the car, and that's the officer that got in and said that the seat was in a long back position. Okay, here's my problem with that. This is a missing person. And this is somebody who had just taken off a few weeks before, just on the spur of the moment. This is a missing person. Why would it be on his mind to say, and remember that it was set back like that?
Right.
That's
and
ridiculous.
I think a big red flag with that.
It wasn't a murder.
By the way, that cop was hot. That was Brandon.
Everybody said that, but I didn't notice.
Woo!
Sorry, I'm old. But
call me.
but he would not have remembered something that was mundane. I mean, there was no murder at
right.
that point
Well,
that they knew about, supposedly.
And the problem with that statement was, from what I understand, was that was not something that he mentioned in his original report, but somehow remembers it and comes back and says that later. That's questionable to me. As hot as he is, darn it, man. Damn it, man.
He wouldn't remember that because it was just one of those days.
Yeah, exactly. But whether it was or whether it wasn't, it still doesn't prove David did it, because if you look at some of the other potential suspects, some of them are quite tall as well. So is it possible that the seat was back because whoever dumped that car off was tall? It sure is. But how does that, but again, here they've got this circumstantial evidence and they're expecting you to jump to the conclusion that it must be David.
And it doesn't even have to be that. I have dropped things down in between the seat or under the seat where I have to push the seat back to get it. It could be something that easy.
Well, and something else that it could be, and this was actually something that somebody had commented, I believe when I was maybe talking on my live or something, but about this, but somebody commented, and I hadn't even thought about this, but that when you change clothes in your car, that you'll move your seat way back. If she had,
Now, they didn't say she changed. I don't remember hearing it at the trial. I do know that Kathy Bona spoke about it, but not at trial. She spoke about it in audio by Preston Swift while she was talking to Preston Swift. And
right,
she said the exact same thing, that she changed in the car, tennis shoes and everything.
right. So I don't know. I mean, it could be anything, but that's the problem. That's the problem. Case in point, that it could be anything. There's so many reasons that that seat could have been back, and it could have been somebody else that was tall. Um, it took a lot of the things that the state was presenting, hoping that the jury would conclude that David did it. Every single one of those things that they were presenting had, other explanations that it could have been. It just didn't prove that it was David.
And
Uh,
they tried to bring it across as that's the only explanation.
right, right. And unfortunately, I've said it so many times. I'm like, okay, they should have done their due diligence and looked at these other possibilities, if not for any other reason, but to clear those other potential suspects.
And strengthen a case. That's like when you're out searching for someone. If you don't find them in that area, you mark it off because you've already searched that area and you start on another. Same thing. They could just
Right.
mark it off and strengthen their case in another way.
Right, right. So, let's see, what's some of the other evidence? What are we missing? We have the cell phone data, we have the computer data. Now, okay. Um, here, everybody knows, and I'm sure, the jurors even know now about some of the evidence that was not allowed in. One of those is going to be David looking at some profiles, I guess, on Adult Friend Finder and Match.com. The next
That
day,
didn't make it in? I thought it did.
that did not make it in. No.
People are talking about it.
Yeah, people are talking about it because it was on the live stream. But no,
Oh,
it did not make it into evidence. And
okay.
for good reason. I mean, it's prejudicial, but the fact of the matter is that even that, it requires us to speculate on David's mindset, on his frame of mind. And I think that that is flawed because, in my opinion, and in a lot of people's opinions that I have spoken with up to this point, is that that really would be more indicative that he felt like she ran off with another guy. So now he's getting even. He's trying to find another woman. Is it toxic? Yeah. Is it right? No. But does it say guilty? No, it
I
doesn't.
know why I thought, I'm sorry. I know why I thought I heard it. I did hear it on TV, but it was when the jury was out and they were just discussing it, trying to get it in there. And the judge said something I thought exactly. He said he could have just been looking there to see if his wife was on there. And that's what the judge said. And
Judge
that's one of
said,
the reasons he ruled it
yeah.
inadmissible.
Well, and just plain and simple, the judge at least could understand, he could comprehend the fact that there are other potential explanations for this. And that jury was stacked with women. So it would have been very prejudicial because every woman on there would have been like, hell no, So, I mean, I know I would have been like, what? No. But our own personal feelings about that would cloud our judgment, I think. It would have clouded the jurors' judgment on.
Plus, she had already filed for divorce. So I mean, come on.
Right. And he knew that, I mean, he at least had an idea that she was messing around, with somebody.
But I mean, on his own, if he was looking for someone else,
Right.
big deal.
That's what
He
I'm
had already
saying.
been.
That's what I'm saying. Like when your partner's already moved on and is, you may not know who, but they're definitely talking to somebody or seeing somebody. And what do most people do in, retaliation? Not murder them. They just go find somebody for themselves.
Can I find a little David? Can I tell a little tiny David story? I know in a conversation that he has said when we thought, well, what do you think about this person? What do you think about this person? He goes, no, they wouldn't. No, they couldn't do that. He actually would defend people that we were like thinking could be that person.
Yeah, I agree with that. I know when we were starting to uncover some of the information and we were starting to, he was not pushing us in that direction. It just so happened that, as a matter of fact, I feel like he was more, if anybody, he was from my memory, I think he was more, about Bill.
He was trying to say that Dustin Swift was preconditioned by his father to say that the person he saw at the cemetery with the metal detector or near the cemetery was provided, the thought was put in his head by his father. And that's what they're trying to say all along, was
Right.
that David was pushing us towards the cells, and he wasn't.
No,
It was Dyer Countyans that did that.
right. Well, so I know from our investigation that David had gotten a phone call from a woman that he went to church with, and her niece was bartending at the farms the night of the Halloween party, and she said that there was a commotion and that everybody went running. She said that Patrick Spoon was one of them that went to see what the commotion was or whatever. And that when he got back, she asked him what that was, and he said there was a fight. And she asked him who, or he just said who, I'm not sure, but he said it was Daryl Sells' daughter and a blonde woman. So that was how that part of it got started. And that had nothing to do, David didn't push that. He got a phone call, and that's how that came about. So, I don't know. I mean, we could talk all day about the witnesses and some of the things that were said to us. The fact of the matter is that Tracey and I were never lying about anything that we said. We would never do that. That's not our style. We are here to find the truth, and that's all it's ever been about. So, of course, when these things were testified to, now getting to the defense, the witnesses for the defense, Chris Nafee, Angela Nafee, and also Dustin, were all witnesses to seeing cells at the cemetery prior to Karen's body being found.
With
And
a metal detector.
with the metal detector. And so, of course, we were jumping up and down when those testimonies made it in, because obviously it vindicates us. We were not lying. I think most people knew we weren't lying, but there were, obviously there were some people that weren't sure, and there were people that were just blatantly, publicly accusing us of lying. So, that was a good feeling. I hate to, I'm not trying to make it about me or about us, but in that moment, I think we both felt really vindicated, because it is now part of court record and obviously public information. So, what else, Tracy? What you got?
Well, it's more of what we have that wasn't in the trial. So it's kind of hard to figure it out. However, what was seen at trial, we have Bill and Kathy Bona stating that Karen could get angry and could get mad at,
Right.
like that. Not that it was a bad thing, but that
Wait,
she
who said that?
was
Who did, what do you?
Preston in the audio with Preston
Oh,
and between Preston, Bill, and Kathy Bona. And she
you're
was saying,
not talking about their testimonies, though. You're not talking about trial. You're actually
right, I'm not.
Okay, so just to be clear, because I don't want to confuse anybody, this isn't something that made it into trial. This is actually an audio that we have of a conversation between Bill and Kathy Bona and Preston Swift that occurred about, well, within a week of her going missing. So that's what Tracy's talking about. I just want to be clear about that. Go ahead.
Yes, and in that, they talked about that she was a
Spitfire was the word.
Spitfire.
That's the word that was used.
She was a Spitfire. And Preston laughed and, he said, yes, she is. She is. And let's just say Karen didn't take shit from anybody.
No.
Let's just put that out there. She wasn't somebody that was going to get their feet wiped on. She wasn't going to let anybody wipe their feet on her.
Right. She had actually been in a confrontation at the dance studio not long before. And I don't think we ever did find out who that confrontation was actually with.
No, we didn't. And we know that she had somebody by their neck against a wall, is what we were told.
Yeah, I mean, I know that's what we were told. I'm not sure if that is exactly what happened, but that is what we were told, yes. But we know that the
and I
confrontation
know,
did
and
happen.
we have the people that we think could have been a part where their child or children went to the same studio.
Mhm. Right, right. So, with the defense's witnesses, I feel like, there were a lot of things that we were disappointed didn't make it in, and I know there are things that the state was disappointed that didn't make it in. I personally feel that if this thing were to go back to trial, so we know at this point David was found not guilty of first degree premeditated murder, not guilty of attempted first degree murder, not guilty of second degree murder, not guilty of second degree attempted murder. And there is a hung jury on voluntary manslaughter. Now, some conversations and a little bit of research on that has turned up that in 2011, there was a 4-year statute of limitations on voluntary manslaughter. So whether or not this gets dismissed and actually goes to trial is yet to be seen. I think we might be hearing something about that soon.
We've gotten several messages on that.
Right.
Several messages.
But also there may be some things going on behind the scene with that as well. So we may hear. I don't know if the state is going to be able to find some sort of a exception to that rule, and whether they're going to be allowed to go ahead and pursue with it. Frankly, I would like to see it go ahead and go to trial because I would like to see him be cleared all the way. And I know that if, I don't think they didn't win the first time. I don't think they're going to win the second time. They just don't have the evidence. They just did not prove that he killed her. And there's too many holes. So I would like to see it go, and I would like to see him get a not guilty.
I would like to see the reason he's all the stuff we have, a lot of the stuff we have. I would like to see that, and then some of these people who didn't come forward
right.
might come
Yeah,
forward.
I wonder if Daniel would be a little bit more aggressive in the second round than he was in the first round. I had a conversation with somebody about that. I don't want to throw anybody under the bus, so I'm not going to say who, but somebody that knows Daniel. And they just said, Daniel is that's how he is. He's respectful always. He's not aggressive. He plays by the rules. Um, and and I appreciate that. But there were so many times in the trial that I was feeling anxious and agitated because I wanted him to be more aggressive. It's like they were fighting dirty.
Be dirty Harry. Get up there and be dirty Harry.
They were being so dirty with him, and I wanted him to just sock it to him. And he did it in such a dignified way, that I have a lot of respect for him in that. But I do hope, pray that if it does somehow make it to trial again, that he would really sock it to him the second time. This is what I've decided, and I don't, this is just my opinion, but I feel like it would be a slam dunk for him if two things happened. One, if he would show the jurors that Dyer County Sheriff's Office had tunnel vision. I feel like he needs to really drive that point, that there were other potential suspects, that there was information coming in that they were blatantly, ignoring, not just ignoring, but actually I would like to see them bring out some of the witnesses who were told to change their statements. I would like to see that come out on the stand, and I would like the jurors to hear about that. So if Daniel could show that they essentially obstructed their own investigation and that they were biased, that they had tunnel vision on David, it was David or nobody. David or nobody. And I've said this before, but I was literally told by the lead detective when I started, and Tracey, you were on the phone. So you were on three-way, you heard this.
Yeah,
And
I heard it from him. Yep.
Detective Cook told me that if I did not have a confession from David Swift, that he was not interested in anything I had to say. He also told me that I was barking up the wrong tree. So it was incredibly difficult to get them to listen, and they never did listen. And when they did listen, all they did was went and told the witnesses to change their statements, and if they tied their boat to me, that they would go down with me. That it was just absurd. I could not believe. I was appalled. I could not believe what they were doing. So
And where was he? He was on the prosecution's list. He didn't make it.
who's that?
They
Oh,
put
Detective
him on the
Cook?
stand.
Yeah.
And somebody else didn't make it who was there from the very beginning. Gosh, what was his name?
Sheriff Box?
Yeah, that's it. Where was he?
I had some people say, and again, I'm not going to name names, but some people from the county who honestly thought that David did do it, that had said to me during the trial that it had not gone unnoticed that Sheriff Box was not there. People were noticing, and people were wondering why. There were a lot of things that really made some people that maybe I think there were a lot of people that had initially been on the David did it boat that came over because of some of the things that came out in trial. All right, so we are back and Tracey is in the car now, so we've had to do this in parts, but I did want to talk about also, there was one thing that I was extremely disappointed that didn't make it into the trial, and that was the audio of the call to the sheriff's office. We felt like that was extremely important. I know that, the jurors had all this kind of random information. They had the three witnesses testifying to seeing Daryl Sells at the cemetery prior to Karen's body being found. But, after talking to the jurors and everything, the ones that I did talk to, um, that information was kind of random and they didn't know what the relevance of it was. And I feel like if that audio had been played, if the voice on the audio had been identified, that could have
They
helped.
could have they could have played the TV interview.
Right. Could have played the TV interview because obviously Mr. Sells was at the cemetery also when the media crews showed up. So what happened to you? Are you there?
Yeah. Do you see me?
Yeah, but my camera just okay. Um Obviously Daryl Sells was there when the TV media crews showed up and he gave them a statement. But from the three witnesses that testified, you have three witnesses testifying that he was there prior to her body being found, and then you have the TV media interview of him there, I believe 3 days after her body was found, and then you also have the audio to the sheriff's department, where he called and was trying to lead them to Harness Road. The mileage was off, but it's still very
We
disturbing.
don't know exactly if it was off because many people believe she was moved.
Right, we
So
don't know.
maybe at that point.
Correct, correct. But the jurors did not have enough information to piece that together, or even the relevance of it. So there were some more pieces that needed to be offered for that to make any sense. So all that to say, kind of to circle back around to what I was saying originally, that I feel like it would be, if it does actually go back to trial, I think that it would be a slam dunk for Daniel if he could connect some of those dots and present this plausible alternate theory to the jurors, as well as to really drive the point that the Dyer County Sheriff's Office refused to look in any other direction but David. With those two elements, I think it would be a slam dunk for Daniel.
And I believe with even more, I want it all to be in there, I do. Because even the call to you, I mean,
Right.
but then they'd
If
have to introduce you. Yeah.
if you put it all together, I mean, first of all, it would be a very long trial. But
Yes.
if you put it all together, all of the harassment, the the intern that accepted money from Mr. Sells and then publicly set out to discredit us and to essentially try to make us out to be like these awful, evil, lying people who were just trying.
Even even paying people to do that.
Oh yeah, we were accused of paying people. That's funny. I can't even hardly pay my bills half the
Not
time.
us, but he
Oh, that,
paying
no, but
people.
at one point I was asked, but I think that was by Dyer County. I don't remember, but at one point there was an accusation that I'm of me paying somebody to say something, which was absurd. I don't have money. You don't know me very well.
Yeah,
Um,
they don't know either one of us very well.
but yeah, it just was a lot of backlash, a lot of pushback, and the information that we were getting, it was just all coming together, and it was all painting a very plausible alternate theory that all we ever really wanted was for them to take it seriously and follow up on it, and they would not do it. They just would not do it.
But I did notice on what they did was the state kind of did their opening statement, did their case on a lot of what we did have. Not that we were the ones that found out the information, it was witnesses that gave it to us. So they kind of, I mean, they brought everything practically that we gave as a timeline of how they were doing it, not an actual timeline. Does that make
Right.
sense?
Well, I'm sure that they already, they had that information. It wasn't like we provided them with that information.
No, some of it was people going to them and them turning them away.
Well, I'm not exactly sure specifically. If you want to be more specific, go ahead, because I'm not really.
Even on the stand, Dustin said, I went there and they made me feel like I was stupid and made me laugh behind my back. It felt like they were laughing at me.
Who said that?
Dustin Swift.
Oh, Dustin.
Dustin.
Well, oh yeah. Well, they did. I mean, they essentially told him he was dreaming. And yeah, it was pitiful. It was really sad that they treated him that way. And speaking of treating the way that they treated him, I know that that was also something that a lot of the jurors had a problem with, was the way that the state treated the children. They were not real keen on the way that they treated, well, the defense witnesses, is, they didn't like what they did to Cade Butler. They didn't like what they did to Ashley and Dustin. And
Who all have lost a parent
right,
during all of this.
right. Yeah. It was really, they came across very unempathetic, and they weren't happy with that. I know some of the jurors expressed that to me. So, but I think this is, we're gonna have to see what happens from here, whether it goes to trial or not. I know that, um, there will be, more to come about it. I know that there are a couple, Dateline, 2020. I know that they're all looking to do some pretty big, coverage on it, and some interviews and stuff. So I know you guys will probably hear a lot more, and you'll probably hear a lot more from us as well. But, as far as the trial itself, we'll have to see what happens, and I'm hoping that we'll hear something soon about that, whether it's, and honestly, I think, Danny's really got to consider whether it's worth the cost. We talked about this a little bit, but
Wow.
an
Yeah.
murder trial is about $600,000, and this one was probably more because there was a change of venue. So are they really willing to spend more money, just to prove a point? At this point, that's all it would be, because by the time it's over with, he'd probably be, time served. And, um,
What what would the point even be?
yeah, I mean, probably
What would
just
the
a
point
simple point
be?
of, probably for them, just a simple point of proving that they were right, I would think. Or, just
It's already not been proven. First degree. Bye bye. I'm
right.
guilty.
And
And
some
that
some of the
will
jurors, had actually said that one of the things that they were debating about in that deliberation room was whether David was responsible for her death because he drove her somehow to leave the house that night, and that he wasn't treating her very well. And so it drove her to leave that night and ultimately caused her death, but not that he actually did it.
I won't say that. Never mind.
It just, a lot of people, of course, I've had the conversation with, I actually called several attorney friends and even one of my DA friends, and put in a call to one of my judge friends to get their opinions on some of these things. And it's been really interesting hearing what they have to say about it as well. A lot of what I'm saying in this podcast, um, I had the conversation with these legal eagles, and they're kind of concurring with me about some of these things. So I feel pretty confident in things that I'm saying. Yeah. All right, guys. Well, we're going to go ahead and wrap this one up. There may be a part 2 because I know Tracey and I have a lot more that we could talk about. But as far as the trial itself, I think we'll go ahead and wrap this one up. And we love you guys. Keep being vigilant. Speak the truth always. And we love you. Bye.